So yeah, our law firm has been general counsel to NC Realtors for many years. One of the things that we help them with is we help them draft forms, but forms do not just come from, nowhere. It's a committee of people on the forms committee. There's about 25 realtors on there, a couple lawyers who are also realtors, but otherwise, these forms we're going to talk about today go through there. They go through executive committee, which is another group. So these forms get pretty heavily vetted before they come out. And so the reason I say that is because I have not been, and nor has anyone else, just been sitting over in Greensboro or anywhere else, devising ways to make your life difficult, okay? There's no conspiracy. I promise you, as Warren will attest, I don't like doing extra work. I really, really, really don't. And I especially don't try to create any extra work for anyone else. So let's start just with a little bit of history of what in the world happened. By the way, just 4 days ago, we celebrated the 1-year anniversary of the settlement. 1 year. We just barely made it a year. So if it feels like you've been through a whirlwind and it feels like things have been changing a ton in that amount of time, you are correct. You are not crazy. Okay? And it's been a ton for me too. The hotline, which is another service that our law firm provides to NC Realtors. I can give you guys that information if you don't have it already. Yeah, it's been very, very, very busy. So when the settlement came out, March 15th, last year, all the forms that we had to that point had been designed to work under MLS rules that didn't exist anymore. So what we did in anticipation of the MLS rules changing is create some amendments, do some changes, do some things to make them work because they were very good. They just were. And I think part of the reason why we didn't have a copycat antitrust lawsuit here in North Carolina was because of our forms. Now, do I know that for sure? No. I'm just saying, as someone who's a litigator, if I was going to litigate that kind of antitrust case and I try to do it here with what the language that our forms had in it at the time, it was not an easy case. Was it there? Sure. It's just not low-hanging fruit. And you got to understand these antitrust lawyers, the plaintiff side, the guys bringing these cases, they're like personal injury lawyers, okay? They will fund a case, and sometimes that funding can be very expensive. But they'll fund a case, bring it, sorry, excuse me. And then, they get paid on the back end, pay massive amounts of money. That's how these cases work, okay? And I'm not saying that it's necessarily a bad thing. If you ever get in a bad car wreck, you will understand the value of a personal injury lawyer. So trust me, I'm not like slamming. But at the same time, you have to understand how the process works. So that's part of the reason that I think we did have a copycat case here. And so when we adjusted our forms, we always knew that it was going to be a temporary fix. Like we had to see, frankly, what you guys were going to do, because honestly, you're way more creative than I am, and it's very hard for me to anticipate how you guys are going to react to things sometimes. Anyway, we didn't know how the market was going to react. We didn't know what was going to happen when we told you guys, hey, you can't advertise cooperative compensation MLS anymore. Go do whatever it is you're going to do. I don't know. Nobody knew. So what we did is when forms cycle started again, forms is usually a year-long process. It starts around about August. It wraps up in April and May. And so we're wrapping it up right now. And I'll give you a preview on some of the stuff that's coming with that. But then the actual changes come out July 1st. But you usually get a preview of that beforehand so you guys can do your training and whatever else, right? And that stuff will all be coming out pretty soon. But first, the final forms approval has to go through the executive committee and also the NC Bar Association for a couple of days. So those two things have to happen before we can get like a final whatever, okay? So when we started this cycle looking at agency agreements, it wasn't just the fact that there was the settlement. There was also other pressures. There was other states were dealing with DOJ, for example. And one example of that would be DOJ got involved with California. They have no cooperative compensation or listening agreement at all based on that. And trust me when I tell you, when I talk about extra work, you definitely do not want to deal with a DOJ probe, okay? They are very intrusive, as you might imagine. So it was one of those things where, you know, we were trying to look at what's happening in other states, look at those other pressures, member input from you guys, also consumer input, and there was consumer input. Especially in the case in Missouri, there was one professor in particular who was bringing up a bunch of things about other forms and the way things worked, et cetera, et cetera. So looking at all that, the forms committee knew we had to look at, all right, we've got these forms. The other thing too is, by the way, you know, with the length of the old agency agreements, a 7-page buyer agency agreement, you know, a 13-page listing agreement. With the conversations you guys were having to have with your clients now, it was taking way longer. And frankly, on the buyer side, if you're having to go through a 7-page buyer agency agreement with somebody, when you're having to explain to them, you may have to pay all this. It was just unworkable, okay? It was impossible. So we started off with, all right, how do we make them shorter, easier to read, everything else, right? So we start with buyer agency, that comes out in October. So that's when you guys see that. And let me just tell you that, you know, trying to do a new form from whole cloth, it was a heavy lift. It was difficult. A lot of work and thought went into it. And was it perfect? No. And the reason we know that is because then after October, you got revisions in January, right? So, and part of those revisions had to do with some of the things we're going to talk about in detail today. For example, the dual agency section. So we'll talk about that. We'll talk about why that changed, and frankly, why the edit was made in October in the first place in the virus. Okay. Then also in January, you had the listing agreement that came out. We'll cover that today. That will, all those two forms will be edited again in July, but nothing huge. Just really just making things a little bit cleaner for you guys, so hopefully you're not having to explain as many things to your agents. But if you want to know like why it's been such a crazy year, it is because of all that. And then on top of all that, probably there wouldn't have been any changes to the buyer agency agreement in this past January, except that in December, the plaintiffs in the Missouri case filed a brief, and they specifically addressed how they felt about amending the buyer agency agreement to get more compensation. And frankly, the way that they worded it really made everybody sit up, because it was one of those things where, at least on my end, you know, you just made us amend all these agency agreements to make sure that we stress that compensation is fully negotiable. And now you have very, very strong feelings about, you know, amending a buyer agency agreement. So the form had to be edited to accommodate that, because frankly, the forms just cannot facilitate and never will try to help facilitate or invite you guys to either accidentally or otherwise violate the settlement. Why? Because, as I explained, these plaintiffs' lawyers in Missouri and others like them, I'm sure they are just looking for a case to bring to if you know, say that somebody's violating the settlement. And I assure you, it's not going to be fun for whoever that is. So to the extent possible, we have to make sure that the forms, you know, do the best job that they can to accept that. Because if you're not in compliance with the settlement, the fear is not, you know, yes, sure, maybe you get, you know, fined by your MLS or whatever. Sure, that's a possibility. That's not really the big elephant in the room as far as I'm concerned. The big elephant is what happens if everybody gets wrapped into a lawsuit similar to the one in Missouri, but instead of it being just, you know, on the same issues as before, it's whether you're in compliance with the settlement or not. And we're not going there. At least if we can help it, we're not going there. Okay. All right. So hopefully that history helps you understand a little bit where we're coming from, you know, where we've been coming from this year. Next year, I anticipate that it's going to be a regular cycle. Unless something crazy happens, you're actually going to get a full year, just like working with forms that you know and understand. And then, you know, there will be probably more edits next year, as there usually is. So one of the things, before I even get into the forms though, if you're not familiar with ncrealtors.org, you need to be right on the first page. Here's the legal Q&As. This is where we keep the Q&As that come out every Monday from the Realtor Rundown. This one here that I wrote a couple weeks ago on guide and best practices for alleged misrepresentations or failure to disclose. probably one of the longest, if not the longest Q&A I've ever written for NC Realtors. Please read that if you have not read it. I mean, it's by far the most common question we get on the hotline. Can my client get their due diligence feedback if there's been a misrepresentation? Does my seller have to give the due diligence feedback if there's been a failure to disclose? Those sorts of questions. And these phone calls, a lot of times, your agents or you guys may be frustrated when I tell you, if it can be worked out by consent, great. And if it can't, tell your client to go get a lawyer. It's not brokerage, okay? I answer this question constantly all the time. I answered it 5 times yesterday again. So please make sure, if you're not familiar with this, it's something that you can go over with your client too if you're in one of these situations. The Q&As make it very clear. There's a little blurb at the bottom there. If you guys want to go over this stuff with your clients, go right ahead. That's what the Q&As are for. They help you guys, and your clients. There was also a Q&A here about amending buyer agency agreements. We'll talk a little bit about that today. So let me stop sharing this and just go to the forms. So here is the new exclusive right to sell listing agreement, the one that came out in January. Let's talk a little bit about this and just go through this form, okay? This fixtures paragraph, right now, the bullets are a little bit different than what's in Form 2T. That'll be corrected in July. It's the same stuff. It's just reordered in the listing agreement. So if it doesn't match exactly, that's the reason why, but that will be changed once we get to July. All right, so unless you guys have any big questions on that first part, numbers 1 through 6, I haven't got many questions on that, so I'm going to go ahead and skip those sections and go to this section here. Yeah. Okay. So one of the things that is very different now from how you were practicing real estate before the MLS rules changed last summer is that depending on where you are in your market, the way that cooperative compensation works, if at all, could be very different, okay? A lot of you are using Form 220, that's fine. While we're on Form 220, while I'm just talking about that form real quick, let me just talk about that. So this section has been made to harmonize with Form 220, okay? And so the check boxes are meant to reflect the sorts of decisions you're going to make in Form 220. Now, is firm's fee, your firm's fee, is any part of that part of Form 220? No, it's not discussed, it's not part of it, it's not anything. And furthermore, in Form 220, some firms have a policy of, we're still going to do this as if it's under old MLS rules, where we, the listing firm, negotiate the cooperative compensation, and then we, it gets paid at closing, whatever. Other firms have a very strong policy of never, seller's always going to pay it. We're not doing it. We're not going to be party to 220. We're not doing it. And the guidelines talk extensively about this. If you haven't looked at the Form 220 guidelines, those guidelines in the flow chart will tell you who must sign compared to who can sign, who may sign. There's a whole flow chart on that. But really, simply, truly, in Form 220, which I have it up here, so I'll just go to it real quick. Who has to sign is in paragraph 1, seller or listing firm, it's going to be one of those boxes that's checked, and then that's who's, must sign. Okay, so seller or listing firm, they have to sign whoever that box is, and then selling. Everyone else is optional. Okay, but those are the 2 parties to the agreement. That's how 220G talks about it. Yes, there's a flow chart. Do you need a flow chart? No. If what I just said makes sense to you, there's other stuff in the guidelines that may help you, but that's one of the things. So now if we go back to Form 101, you can see in the cooperative compensation section that there's a checkbox for listing firm. And what you can think about this option this way, okay? There are some sellers you have who are just like, just sell the house. I don't want to know. I don't care. Just sell the house, okay? That's what this box is for. The firm is gonna offer the cooperative compensation. And then if you look down here at little Romanet I, it talks exactly about how the money moves. And this is the reason why you do not need any part of cooperative compensation in subparagraph B up there under firm's fee. Because Romanet I says, if you, the listing firm, offer cooperative compensation, and it is agreed to, then at closing, the seller is gonna pay it to you, then you're gonna turn around and pay it to the cooperating agent. And the seller, for some reason, decides to get squirrely, then they're gonna be in material breach of this listing agreement, okay? This is why you do not need any part of cooperative compensation in firm's fee. These Romanets tell exactly how the seller is supposed to do that, okay? So then in the second checkbox in subsection C here, the second checkbox, think about it more like a seller who says, or let's say your firm is a policy, where the seller's the one who's gonna be signing the Form 220, you know, that we're not dealing with it, we don't want to be party to it. Frankly, you know, it makes a lot more sense because I don't know if you guys have run into this situation before, but let's say that, you know, the transaction goes sideways, the seller breaches. It used to be under the old MLS rules that if a buyer agent called me on the hotline and said, hey, you know, can I get paid? The answer is, that's a tough case. You got to show that you're an intended third-party beneficiary of contract you're not even a party to. You're not a party to the seller and the listing agent's, you know, listing agreement. And so in order to do that, in order to get paid, you know, that's what a direct case would look like. It's not easy. I've never heard of a successful one being brought, okay? Now, if the seller signs the 220 with the buyer agent, and then the seller breaches, buyer agent, have a field day if you like. And that is really, if you think about it, it's not a disservice to your seller if that's your policy. It's really not. What it is just accountability for the seller to do what they said they were going to do. In any event, I'm just saying there's a big difference between the seller and the listing firm offering and paying the cooperative compensation. In any event, the second checkbox, that's where the seller is going to do it directly, but you need this authorization. You can't just go out as a listing firm saying, hey, my seller may be offering such and such for cooperative compensation unless you got that authorization, right? You can't, you definitely want that in writing, because if you're going to put it out there, Real Estate Commission expects you guys to have your advertising accurate. This is what that second checkbox is for, so that you have the authorization you need to advertise cooperative compensation and then eventually enter into it. Mind you, the language in here for both these checkboxes is the same as the previous form. It's an authorization. Authorization is not a mandate. There's a big difference between those two words. You're not mandated to offer anything. You're just authorized to do it. It doesn't mean you have to. So, you know, by the way you're signing this, and it was true under the old listing agreement too, is that by having authorization, that doesn't mean you have to offer that amount, or it doesn't mean it has to be that amount. That's why I've had this call in a while, but I was getting this call a bunch, or if you got buyer agents that are like getting upset at you as the listing agent because you're not telling them what is in here in these paragraphs, in either an old listing agreement or this one, that's just not their business. It's not a buyer agent's business. They're not holding you accountable. There is no mandate here. It's simply negotiable. All right. And then the third checkbox in part C is, firms attach policy if you have one. It's perfectly fine. All right, so that's the cooperative compensation section. Let's just back up a little bit to firm's fee. There's actually a Q&A that came out on this on Monday that specifically addressed single agent, dual agency, as well as unrepresented buyer. I'm actually, as soon as I get off this trip, I've been traveling for a couple days now. But what I may do is when I get back, see if I can just add a few more lines here to the other fees line, so you don't have to attach an addendum. I'll see if I can do that yet this week. If not, maybe early next week. I'll work with Lee on that. But on the other fees line, it can be anything that you like, whatever your firm wants. The Q&A talk gives you some, if you want some language, just as a suggestion on how to address those two things, unrepresented buyer and single agent dual agency, it's fine. Otherwise, You know, cooperative, if you think about it, you know, think about the good old, the good old days of the MLS. They used to facilitate all this cooperative compensation stuff, and you didn't have to really think about it. But if you think about it, you know, under the old MLS rules, when you as a listing agent made an offer of cooperative compensation in the MLS, there was never anything in the listing agreement that talked about, you know, other cooperating agents in your firm. There's never anything about two agent dual agency, right? Firm dual agency, we call it that, right? There's never anything in there about it. It's because if you're gonna be, you know, cooperating broker was never defined in the MLS. It could just be someone else in your firm. Same thing here. So if you've got, you know, a cooperative compensation, you have two different agents in your firm, then that can work that way. But if you want to address it in the other fees section in subsection B, you know, if you want to do an attachment with your firm and have a policy on that, that's fine too. So, you know, just so you know, there's actually two different ways to do that. Either one is fine, however you want to do it. As long as you're, you know, communicating all this to the seller, then that's fine. But you have to think about it this way. And this is really the fundamental premise that, it's just the reality of where we are. And the reality is that firm's fee is just different from cooperative compensation. And the buyer has their own obligation to pay their agent, and the seller has no obligation to pay that. And it's true that that was true before, but it's even more true now. And I think it may, depending on markets, fluctuate wildly. Right now, you know, you guys may still be in a market that's primarily being driven by sellers. And that's, you know, this just is sort of been for a little while now. But many of you who've been around longer than that know that markets change. And so sure, sellers can feel fat and high on the hog right now if that's what they want to be. But it ain't gonna be like that forever. And so having these two things separate is important for just how you're gonna have to navigate, you know, two different kinds of markets. So the form is meant to reflect that and facilitate that. I do apologize for the upending of the universe. But I didn't ask for it. I didn't ask for it. I'm just trying to give solutions to help navigate. All right. So, any questions on these two sections here?
Question?
Yeah.
So really, as a buyer's agent, having that Form 220 signed, it's much better protection as a buyer's agent because you have a contract with the seller signing it, you signing it. Then
Yeah.
if you don't have it as buyer's agent, you won't win in court probably.
Yeah, I mean, if you as a buyer's agent have it signed with the listing firm, and there's actually a little blurb we'll cover a little bit later, but there's a section in 220 that talks specifically about that. If the listing firm doesn't get paid, then yeah, you as a buyer agent probably not getting paid, just like it used to be under the old MLS rules.
Now, the old rules that we could go after the firm for our commission, the listing firm,
If the listing firm got paid,
if they got paid.
yeah. If they didn't get paid, still a difficult case. Yeah.
I have a question. Pam Smith, Love the Legal Hotline. I reach out to you often. So, and I feel like I know these forms, but could you just explain what the benefit of the second, what's the difference where it says seller may offer? So that's saying that, so say the firm's commission make up a number 20%, and then you check seller may offer 15% of the gross sales price for the 220. Does that mean if Dawn brings an offer, she has to request it?
So
I guess that's where I'm confused on the first two. Because they've already agreed to pay, right? So why wouldn't they just agree to pay in the first part?
you mean in part B?
On C, I'm talking about paragraph C,
Mhm.
the two bullets.
Mhm.
So the first one is authorized to pay to a co-broke agent, cooperating agent. And then the second one is the seller may offer, if you know, go back to
So-
the form. Yeah.
So I'm switching over to Form 220 because,
But let me finish. So that means that, they're offering it, but the buyer agent has to request it still?
no. So here, the reason I put 220 on the screen is because there's nothing in this form that says which side it has to come from. And the guidelines to 220 actually talk about this. It can come from the buyer, it can come from the seller.
Right.
It can go either way.
But it
What's it-
clearly says the firm's fee in B,
in B,
and
right,
in C, it's the cooperating compensation.
right.
So I
And-
just,
And really it has to do with who is offering the cooperative compensation. Is it the listing firm or is it the seller? Who is going to sign this? So look at paragraph 1. Is it gonna be the seller checkbox that's gonna be paying it? Gonna be a party, gonna be the responsible party under 220, or is it gonna be the listing? Because contractually, like what you're saying, it's a big difference between the two. Right? Because if you're the buyer agent, you would have a contract with the seller directly. You know, if you sign it that way, or if you're the buyer agent, then you have a contract with the listing firm directly. And the big difference is actually in paragraph 3 right here, where it talks about if the listing firm is in the second to last sentence, or is it the last? Let's see. Yeah, okay. If the listing firm has agreed to pay the fee, the listing firm will not be obligated to pay if seller breaches the contract and listing firm's not paid. So that little sentence there makes it clear that, you know, if the listing firm is offering on behalf of the seller and the seller decides to breach, the listing firm's not gonna be on the hook. That means that you as the buyer agent, you know, may not be able to be paid if the seller breaches. Now, it's always been the case where if a listing firm goes after a seller because of a seller breach, and then the listing firm gets paid, and I think the buyer agent's right to get paid is pretty easy and pretty clear. But absent that, no. Now, paragraph 1, if the seller's the one signing this as the responsible party and then they breach, yeah, the buyer agent's gonna have a pretty, you know, they're gonna have a breach of contract claim directly against the seller. And these two check boxes, it's really meant, what I can tell you is that the top 2 check boxes in subparagraph C here is just a matter of, you know, the firm is offering it or the seller is offering it. You know, it's just a matter of phrasing and who is gonna sign the 220. Is there that big of a difference? I mean, probably not on the
Something that goes
advertising
down,
side,
yeah.
but on the back side, there's a big difference. On the contract side, there's a big difference.
I think, correct me if I'm wrong, I think the big question she had was the choice of the word may,
Yeah,
or seller may offer.
yeah.
And I believe, my understanding is, we went that way because the seller may choose not to pay that percentage amount if the offer is too low for it to make sense for them to take a low offer and pay the salary fee, and then it all becomes negotiable. Both parts become negotiable.
Everybody sees that.
There's no, I can tell you, there's no like, don't parse the language too much on this one. It's really, the second checkbox is just meant to give you, the listing firm, like parameters of what you can advertise the seller as off. That's it. Like, it's not, I promise you, since it came from my own brain, there was no special thought there.
I bet you can.
And by the way, it's been a really funny thing, like, over the last year. Like, you know, as I've been writing Q&As, doing forms changes, and it's almost like, I mean, it's almost like I've been able to watch in real time. Like, if the apostles in the Bible were able to see, you know, how their words were gonna be interpreted and ripped apart and scrutinized in real time. Like, that's what I've been watching. And I'm just like, I didn't even think about anything you're talking about right now. You guys are, anyway.
Why would anyone choose to pay, like, for the firm to be responsible? It just like straight shot directly paid for from the seller would make much more sense, and the firm not to get involved into compensation. It's gonna go to the same place in the end anyway.
Yeah.
Why would you jeopardize the firm if someone decides to come after the commission?
Well, I don't think the firm's very jeopardized.
Well, obviously, if we didn't get paid, yeah.
Yeah, no,
But not by
listen,
figure.
here's what I can tell you, and this is not from me, like, you know, this is, what I can tell you, this is directly input from the forms committee, so you're talking about, you know, realtors all across the state. You know, forms committee, we got obviously people who serve from out here, we got people in Murphy, we got people everywhere in between. And what I can tell you is that there are some firms where that first checkbox, like, that's their policy, like, we are gonna take care of our client. We don't wanna have to bother them with, you know, signing a 220 all the time, et cetera, et cetera. So it's, think about it more like, we're just gonna be a full service firm, this is how we do it. And they feel that that's definitely how they wanna operate. Meanwhile, there are definitely, plenty of firms where that second checkbox is the only one they're doing. And some even other firms, they're not doing this, they're not doing cooperative compensation at all. They're just doing does not, in the first checkbox in part C there. And then what they'll do is sell concessions, and that's all they do. That's it. They won't do anything else. So it varies widely across the state. Yeah, I don't know which one to use.
I apologize if I'm getting ahead of things here, but, I've had my head in this thing for quite some time now. And honestly, I've come to the conclusion that we could get away from all of this mess. So I'm kind of asking you more for perhaps an update. If we could put the compensation in the contract, we wouldn't even need all this mess. We could do away with the 220 form. I mean, the settlement, they don't want us to do preemptive optimal compensation. We could do away with that. And just let it be spelled out in the contract. The buyer's agent and the client are signing an agreement which says what they're getting paid. Then you go out in the marketplace, you find the house that you want, and you put the compensation in the contract. It's pretty easy to do that. We could get away from all of this mess and confusion, in my opinion. Any word on where the real estate commission is with compensation and contract?
Legislative.
So what I will say on that, I agree with you. I don't speak for NC Realtors on this, so I don't speak for anybody except myself. This is just my personal opinion. But my personal opinion is, I agree with you completely, that all of this is very much like trying to work within the rules. But in fact, practically speaking, cooperative compensation is being negotiated as part of the contract, which is, I believe, a much more appropriate place for it to be.
I agree.
The real estate commission, as far as I know, they haven't moved on this, but I will tell you, in fact, I'll just give you a little preview of what I hope forms changes will bring in July. Like I said, they gotta be finally approved, but what forms committee has approved for July 1st, and this will be in the vacant land contract and in 2T, the residential contract, is the first page is gonna be refreshed completely. Well, the whole thing is gonna be refreshed. All the note boxes and warning boxes will be gone. That language will be incorporated into the contract. It'll still be there. But all the boxes are gone. I've always found the contract to be very cumbersome to read those boxes in there. Nobody reads them anyway, whatever. So those are gonna go away. Then the first page is gonna be restructured as like this, okay? So at the very top, you are gonna have parties, right? Buyer, seller, then you're gonna have property description, then you're gonna have the purchase price, just like usual. But because the boxes are removed and because of the way it's reformatted, the bottom of the first page, the very next line is gonna be seller concessions. And it's gonna be a monetary amount or a percentage of the contract sales price. There'll be two different blanks there for that.
Oh, I like that.
Then there will be due diligence period end date, and there'll be settlement date, all on the first page. And the reason for that, the reason I bring that up is because maybe if enough firms start just using seller concessions instead, because there's no cap, it's not gonna hit your interested party cap. Lenders have already changed the rules on that. And I'll add this to that. If buyer agents could just roll their buyer agent fees into their loan package under lender rules, all this would also not be necessary. So there's actually two different ways that to me seem very common sense where we can fix this. But, as far as I know, the real estate commission, there's no movement to change the rules, but maybe seller concessions on the first page, if people start using that, they realize that it's not like as dangerous as they think. 49 other states do it that way. We're the only ones that have this rule. And so that's why we have to deal with this.
Our MLS, we incorporated seller concessions into the fields. I mean, I don't think many agents even use it, but that was the whole purpose of it. Let it be known that the seller's flexible, working to work with concessions. So
And it can't be a percentage.
I'm really disheartened to hear that the commission is not moving on this.
It's not,
because
It's a legal issue.
No.
it's law,
No, it is
but they're, right, like it's.
if the real estate commission wanted to
Wanted to.
change,
What?
it would
They could change it.
Yes.
And if they're not making any. movement
Listen,
on it-
I will tell you this, that if there is movement on it, I just don't know. For all I know, there is. So, but as far as like my knowledge on it, I don't have any knowledge that they're moving on it. And we are continuing to advocate, to change it, because what I've always heard is that they don't want agents to be a party to, any purchase contract. All right, well, they're not a
Yeah,
party, they're not.
I've heard their
But they're not
reason
signing
for
it, but they're not, no agent signs it, and furthermore, it'd be, I guess I'd be able to give that argument some credibility, except that all of this drags the agents into it anyway.
Well, they've
So-
totally eliminated our transparency, and if we could bring the transparency back, we wouldn't have all these issues, to be honest with you.
Well, did you, did you have a question too, or was it the same?
Oh, I did, but this is kind of an exciting topic.
Got it, I'm gonna be here for a while. All right, yes.
Check salary concessions. Doesn't the mortgage companies have a limit they can put for salary concessions so that you can't get away with doing that, especially with larger property?
Well, interestingly, I mean, I hear what you're saying on that, and yes, but the way that it works, for example, in South Carolina. They have a line for that, they do it, and then what they have on that same seller concession line is this is how much goes to the agent fees, so that the lenders know that that doesn't count toward whatever the cap is. So, well, I don't know, I'm gonna enter, Forest Committee has approved a form. And it's like a half page, it's a very, very, very short form, but basically what it says is that, the agent, have a contract with this client. And if there's a successful transaction, then here's the amount of compensation we expect to receive. And the reason for that form is multi-purposed. One, you may have sellers and builders demanding your agency agreements, or lenders for that matter. So hopefully there'll be a one-page, affirmation of your compensation, so you have to turn all that over. If you're having to deal with that, I don't know, if you're not dealing with it, it's fine, but it's a big problem in other markets. And also the same form could be something where if there's, seller concessions or something like that in the contract, then you can tell the lender or the firm or whoever, what your compensation is out of that concessions, so. In any event, all right, well, let's keep moving. Oh, yeah.
I only deferred.
Oh, okay.
If in that second box, if the word may was changed to shall. I think that would tighten that considerably, because may can also mean may not. That's all.
So it's offering.
So there is.
Agreed.
It's, I do obsess over words.
But wouldn't that make it non-negotiable?
But that's
If you say shall? Yeah.
Well, it's already non-negotiable on the check of the budget too.
That's
It
authorized.
is.
That's authorized. That's different.
Oh.
That's not mandated. It's-
Mhm.
He just.
Yeah, here's the thing, the second checkbox is just meant to, give flexibility, because the way it would work if you do the second checkbox is you put the whatever amounts you put in there. And then what would happen is, you, as the listing firm, go out and you're gonna put whatever in your advertising. I would suggest something like, with an acceptable offer, seller willing to offer up to whatever amount, okay? The amount here. And then that way it's fully negotiable, but at the end of the day, and this is really the reason why the word may is in there. What if the buyer submits an offer or submits a 220 and says, here's the outline of my offer, here's our 220. Which we'll get to 220 on this, but that would be the preferred way for these sorts of things to work. Then the seller doesn't have to sign it. So there's just nothing binding about this, because the seller and the listing firm are the parties to the listing agreement. This is really just it is just something to give you cover. If you're gonna put an advertisement out there that says something of what I just, said, then it gives you the cover to say, hey, he was allowed to do that. If the seller refuses to sign it, there's not much you can do about that, except, and this is a really important part of this. This is in the old form and it's in the new form. Right here, this word, this is the most common way sellers violate their listing agreements, they just don't cooperate. So there, this paragraph where I highlighted this, there's a couple different things here that talks about what the seller needs to do. Same thing in the buyer agency agreement. Well, understand this is a really fundamental underpinning. Clients violate this all the time. And sometimes, like, let's say you got a seller who's just not providing reasonable access to the property. They're just being difficult. That is gonna be a material breach, maybe of the purchase contract and your listing agreement, just by them doing that, if they're being really stubborn. So just know, that language is still in here to protect you guys if you get in that kind of a situation. All right, moving down, let's go, oh, sorry, on the total cost line. If you've got a whole range of fees on the other fees line in subsection B, you can just do C above or NA. This line was gonna be changed to total cost and then in parentheses here, optional, come July. Just because the way people are filling out the firm's fee section makes the total cost line just kind of a little bit unworkable.
Can we remove the dollar sign that autopopulates all the time? That's the most obnoxious thing. If you try to type anything into that line, there's a dollar sign and you cannot go around it. You just need to send it to DocuSign and manually type it into DocuSign.
I think you have to tell that
Yeah, hit the space bar. It'll-
I did, mine did.
on your zip forms.
Mhm.
That's it. But you can tell Dan and he'll tell zip forms.
Right.
Okay,
Tell
okay.
Dan.
Yeah.
I think someone already had.
Don't worry about that, John, we'll take care of it.
Appreciate it, Margaret. This line, I tried, but it's not my favorite part of this form, but I think the change for July will, be a little bit easier to work with. Hopefully, we don't have any more of that. That is, ugh. I agree with you, that would be very good. Anyway, all right, so moving on down, let's go to dual agency here and talk about this section. I want to go back to 2022, when the agency agreements were amended then on the dual agency section, okay? And in 2022, what was changed was this. So this is the old listing agreement and this takes forever to scroll through this.
Tell us about
Oh my God. Okay.
it. And it's cross too big.
Here we go. Here's the initial section of the old form. And in 2022, when this came out, I was scratching my head. I did not like, to me, the seller does not check boxes were, had to harmonize with designated agency. And then my partner Will was like, no, you only do designated agency if you're gonna do that. And then you just initial and you don't do the check boxes. And I was like, well, that's not very clear, et cetera, et cetera. Fast forward about 3 years, and then we change the designated, the dual agency section to this. And there's a huge uproar because frankly, people have been filling it out wrong the entire time. But here's the point of the 2022 change. It's down here. It's where the, this word. If you're directed to do designated dual agency, you have to do it. That's it. Okay? You don't get to do anything else unless, and that's what the rest of the line is, unless you can't do it by law, which obviously if you're a BIC and a provisional broker, designated dual agency is not gonna work because the BIC has to supervise, right? Or if your client just gives you some other writing to say, we're just doing regular old dual agency now because you got a buyer to do whatever, that's fine too, okay? That's what that language at the end of the designated dual agency section means. And that's true in the new form as well as the old form. But the directs line was the line that the real estate commission and what regulatory affairs at the time really wanted to make sure that when you did the dual agency section, it was clear from the get-go what you were doing with your client. And if you later changes, great. But otherwise, if you're doing designated dual agency, then that's what you have to do. The reason for that is because the commission at that time was getting complaints where consumers were simply confused about, well, I thought I was getting designated dual agency, but it turns out I was just getting dual agency. And this is no small matter. I will just give you an example. A BIC called me a while ago and said, we got a big problem. I've got two agents in my firm. One represents the buyer, one represents the seller. Both buyer and seller, one is designated dual agency, but these agents have been just blah, 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 back and forth as if they're, there is just regular old dual agency, or firm dual agency. And it costs, we weren't talking about small monetary damages to the seller. I mean, they lost out on a massive due diligence fee and some other stuff. The buyer also lost out on some things because these agents were just like, oh yeah, well, my client doesn't care about that. Sure, your client have this, blah, 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 right? That's not designated dual agency, okay, right? So just so you know, what happened is, of course, the reason it got to me is because, the clients have now found out about this and they were livid, okay? But a complaint hadn't been filed. So I told the BIC, I was like, listen, you are gonna bring the hammer down. You're gonna do what, this is the reason you take all this extra CE and everything else to be the BIC. You're gonna bring the hammer down on these agents. You can fire them if you want, but if you don't want to, it's fine. That's up to you. Ended up keeping the agents, giving them some pretty significant discipline internally within the firm. Education classes, they had to make, things right with the clients. Clients got brand new agents that didn't know anything about the transaction. Fortunately, it's a big enough firm to accommodate that. And then we just crossed our fingers when the real estate commission complaint got filed. Then we were just like, all right, well, we knew about this and here's what we did. And to my shock, the real estate commission, this is not, what's this?
I think it unshared your screen for some reason. You might have to go back to the other.
Here, I'm not in the meeting anymore.
Oh.
Hold on.
Yes, it would, man.
What happened here?
Yeah. I think she wanted to come downstairs. So. Well, we needed a little break. Hey.
We're not.
Yeah.
All right. Anyway. So, everybody can hear me in Zoom link? Oh, hold on. So, good. All right. Well, I'm gonna check the chat here to make sure people can hear me. All right, looks like we're good. Okay. In any event, when the real estate commission got the complaint and we, told them everything that had been done up to that point, the real estate commission wrote back and said, thank you very much, have a nice day. Which I did not expect, I expected them to do something, but just so you know, the delineation and the expectation of designated dual agency and getting that correct is not a small thing. It has to be done correctly. So let's go back to now the new listing agreement that came out in January. So you got the first two initial lines where the firm may not or may act as a dual agent. Okay, so that's the threshold issue. Then you're going to pick one of the next three, and the next three lines are mutually exclusive. It's not like they are, somehow you're gonna do one and not the other. If you're doing designated dual agency, you cannot do single agent dual agency, obviously, right? You can't build a firewall between yourself, right? And you can't do just firm dual agency with two different agents either, because if there's no firewall, then it's not designated dual agency. So That's why the three lines are structured the way they are, and then you can see on the designated line, the blurb is still there where it's not allowed by law. Or if, you know, the client later wants to change it because you've got somebody that wants to see the property, and let's say you're in a single agent, dual agency situation with that, then you can change it. Just so you know, the agency amendment form 710, it's been completely revised for July, as long as it gets through executive. And part of that is, it's still one page, so it's not like, you know, anything crazy. But instead of just a bunch of blank lines, although there is still a bunch of blank lines, it's just that it's not almost exclusive with that. There's a section of it now just for dual agency, so you can check a box, send it to your client, and hopefully facilitate changes in dual agency a little bit easier. But that's why this is the way it is and why it's structured the way it is. And it is not because anything has really changed from the old form to the new form. Instead, it's been more about trying to make sure that and this is not, you know, NC Realtors expectations. This is from Regulatory Affairs, the Real Estate Commission. They really wanted it to be more clear. So that's why this section is changed. Yeah.
So a scenario, when I list a property, the seller always says, have you got any buyers for my property? Oh, you know, I think I do. So they initial allowing dual agency, because I've got a buyer, and I'm a buyer's agent. So I list the property, I start writing my offer up, and then another agent in my office says, hey, I'm writing an offer up on your new listing with the buyer I'm representing. What do you do in that situation? You've got one agent who's a dual agent, another agent would be a designated dual agent because they've got their own buyer.
Mhm.
So why couldn't you initial both of those blocks depending on what the situation is?
Yeah, I think that's an interesting scenario, and I think that the way it would work now, and I think what the Real Estate Commission would expect, is that, like, if you had both these lines initially, even though it's not, you know, designed that way. But maybe I can tell you for right now, there's at least no interest with combining these two lines here. The firm dual agency and the single agent dual agency, because there's such a big difference between the two. So what I would tell you is that in that listing, if you're sitting down with the seller, he asks if you have any buyers, you say yes. So I'm assuming that means you initial the second line here where the seller is authorizing the same agent to represent both.
Right.
Fine. Then I think in your scenario, when that comes up, all you do is send an email to the seller and say, hey, there's another guy in my firm who also has a buyer, would that be okay? And if the seller says, fine, yeah, great.
Well, why
That's,
is that any different than doing it up front? Because it's the same conversation as you're having it.
We both
You're
designated agents.
you're explaining it up front.
No, you're not a piece, you know.
Well, you still hit the firm, it's the firm. It's still firm.
The situation, if I'm a
He's
dual
designated
agent,
agent.
and have a buyer there, so
Be designated.
I'm explaining the same thing after the point, so then so actually, if I send him that email, he's authorizing to initial both boxes. So if I can explain that, why can't I just do that up front?
so here's the issue from just the practice side. And listen, I'll be happy to bring this up with the forms committee, by the way, because I'm not disagreeing with what you're saying, but I will give you the counter of this. You explain these three options to the seller, and it may well be that the seller's gonna be like, you know, absolutely not, I do not want the same agent representing both sides. You
Right.
see what I mean? But they'd be comfortable with two different agents in the same firm or with designated dual agency. I just think that in your scenario where you have an amenable seller, then yeah, sure, it makes total sense. You know, maybe several of these lines could potentially apply. Sure.
In one way, but another way it would apply, and I've had this happen recently, when I've approached somebody whose property's not on the market, and I said I might have a buyer for the property, and they decided to list it with me, and they'll say, well, when we negotiate out, if your buyer buys it, I'll pay less commission. There used to be a variable rate commission, which we had, but if another agent sells it, then you'll pay the full commission. So you don't want to get in a scenario, if I have to designate an agent to represent the buyer and seller, then they're gonna have to pay full commission because you got two agents in that time. So it's actually hurting the seller and the buyer because they can't do a lesser commission that way. So my question would be, if I do a listing agreement and my seller initials both of those lines, what's gonna happen to me? Is that a violation? Is it what is that?
Is it,
Because I'm potentially doing that if I do it after the fact, but if I do it up front, what have I violated?
I think it's fair to say, correct me if I'm wrong, that this was changed or this is structured a lot of the way it is because the real estate commission sits on both of these committees. This is the way the real estate commission wants us to explain it.
But is it a violation? It's not a violation unless I do something wrong.
Listen, if you fill the form out incorrect, say, and initial several lines, which I'm sure some agents and firms do, okay? The issue is this, like, I've come out here plenty of times, I don't follow the speed limit, okay? I just don't, I rarely do. But I tell you what, one time I did get caught. And it was a hefty fine. You guys have hefty fines out here. I don't know if you know that or not, but they are hefty. It's the same thing here. It's gonna be 99 to 1 of, people filling it out and nothing happening. But if you're that one, and it's because something has gone bad, then yeah, like, that's what it is. So I guess that's the best way I can answer this is that, are you necessarily gonna automatically be in a violation because you fill out a form weirdly? No. What I would actually suggest to you is pick one of these. And then if you really have something that, of what you're talking about, then you can explain it, down here in 19 in the additional terms or attach an addendum. If you want to, as long as you are explaining it clearly to your client, then I don't think that I don't think there's an issue with that. I really don't. But as far as what the form needs to facilitate to try and, from a risk management perspective and what the real estate commission expects, then I can tell you for right now anyway, there's this. But maybe like what you're saying, it would just be something where, go back to.
I understand what Richard's saying, that's 100% could apply in this case, that would happen all the time, I don't see any issue with having both boxes checked, to cover the bases
It's two different,
visually.
two
They're
different
going back.
transactions.
I would say this, if you got a client who's willing to do single agent dual agency, then yeah, they're of course gonna be fine with the other ones, and it's just a matter of getting written direction.
That's a good point too, because if they're fine with single agent dual agency, then designated dual agency is an improved situation. Not worse.
Even two agent dual agency is probably an improvement, unless they're paying a different amount, like what you were saying.
So should we have an initial single agent dual agency and then immediately send them an email, and say, hey, will you do designated dual agency, and have that in our file?
Well, isn't the listing agreement with the seller? So the seller has the listing, I'm sorry, with the firm, listing agreement with the firm. So even though Richard is the listing agent within the firm, he's still designated. He could still be a designated agent,
That's
correct?
not what the question is.
I mean, if you're the listing agent,
Within the listing agreement is with the seller and the firm.
yes.
And Richard is an agent within the firm. So if he's working directly with the seller with a buyer, he's still a designated agent.
Can't be
Within the
designated
firm.
if you represent.
Not designated dual agent.
It's just not a
Direct
direct.
on both sides.
Yeah, it has to be broken out.
Feeling in my hand.
Yeah.
So easy on Zoom, you just push the button. So I understand that we're not supposed to tell our clients what to do, but we're supposed to explain this stuff.
Oh, yeah.
So what situation would there be, where there would be an advantage to them selecting, you could call it the first or the third, the one that says seller does not authorize the same agent to represent both seller and buyer. That sounds like it's really good. But really, 100% of the times I can think of, designated dual agency is better for the client. So why would we ever tell them that that first option was a good one?
Well,
Did I ask you? It's not.
No, some firms do not do designated dual agency. Some firms only do designated dual agency. So it really just depends on, what your firm's policy is. There's not like a right or wrong on any of this.
Yeah, well,
So if designated dual agency isn't an option,
Sure,
that first one would be a good idea.
sure.
but if it's a situation where you're having to explain it, so I'm talking to a seller and I'm explaining what these lines mean, I say, well, here's your choices. If I have a buyer would you allow me to be a dual agent, single agent, dual agent? Oh, that's a good idea. And then I'll say, well, or another agent in my firm can sell it, they can represent their buyer and represent you. Yeah, that's a good idea, but you can only initial one. And so I'm telling the seller, these are different options, and he's agreeing with it, and yet he's not allowed to.
Yeah, but
allow.
Or I suppose.
your scenario assumes you got a seller that's just cool with all of
My sellers are all cool.
them.
Do whatever.
I said, make the form do that. I'm telling you, there's plenty of sellers who would not be cool with all of
I
them.
agree, I
Why
understand.
don't you explain it?
I understand.
All right,
Why do we have to toss in the idea that it's gonna be illegal? In other words, that kind of throws a red flag up and says, hey. Designated agent, designated dual agency is illegal. Now, why? You know, now the public's gonna say, it's gonna make them apprehensive. The only reason we have to put that in there is in case, it's provisional broker, and said, and that's within our realm. It has nothing to do with the, the seller agency.
Okay.
well, I mean. Roman at one, I mean. There would be several different scenarios. Well, two common ones come to mind. One is the provisional broker BIC, right? So that would be a situation where it wouldn't be allowed. But also wouldn't be allowed if, another agent had confidential information from one party or another, so.
But that's our practice, that if we're illegal in our practice of that. I'm kind of dividing it that way. Does that make any sense?
It's not saying it's
Because
illegal.
because this is for the general public. We never had to put not allowed by North Carolina law before.
Oh, no,
It was an act.
oh, it was in the old one. I will show you.
It was in the 2022.
It's been there at least for the last 3-4 years, it's right there.
Yeah, well, that's what I'm saying. Before that, we didn't ever have nothing in there.
Well, like I said, the change was made in 2022 to especially make it clear that if you're doing designated dual agency, then that's what you have to do.
Okay, okay, appreciate that. And then we ask one other, I don't have my question formatted the way I need to. It says seller. The last part of that says part 2, seller. What's it say?
Authorizes firm and right to practice dual agency only. So that's what we're saying, like, you can just do an email.
But that's like going back in reverse. I mean,
Sure.
we got the first sentence that says this, and now we're bouncing back to the previous, sections of above.
Well, like what he's saying, let's say you talk through with your seller about these 3 options and your seller says, all right. Based on that, I only want designated dual agency. That's it. Like, I want to have the fullest representation possible. Okay, that's what you decide. Okay. But then, like what he's talking about, then things change. You have someone else in your firm, or let's say you have a buyer, right? And it's a good buyer, and somebody who's gonna do a good job and have a good transaction with your client. Then that's when you would say, hey, seller, here's what I got. I can't change this because, in our listing agreement, you want a designated dual agency, but this is not designated dual agency. I have the buyer. Then that's something where, the buyer says, or to the seller says, all right, fine, bring it. Let's do it. That's what that's for. All right, we'll keep moving.
Can we get to paragraph 16?
Oh, yeah. Let's do paragraph.
Just me think sellers don't read the contract. Everybody read this.
I'll tell you what,
Oh my God, I'm so tired.
I apologize to you. Like, honestly, if I would have used the language that was in the interim guidelines for the 16 instead, we wouldn't be having this discussion.
You just have to add.
It's one of those things, it's just one of those things where, I don't know if you've ever written something and to you it was very clear, but to, apparently it's not clear to everyone else. Anyway, this is not, the seller and the listing firm are the parties to this agreement, not buyers. This has nothing to do with buyer costs. What this has to do with is the fact that you guys spend years developing relationships with your vendors to come out and do things for your sellers. And then it's a pretty common hotline call where sellers will turn around and then not pay. And then you're stuck with this person that you have, worked hard to develop this relationship with. And now you're stuck with what, a $5,000 survey bill? They're coming at you and being like, hey man, you told me to come out and to survey this property, and now I'm not getting paid. So That's what this is for. If the seller, has incurred costs, you're using your contacts, they've directed this, then they need to cover it. This will be substantially edited in July to make all that really very clear. I apologize for it not being clear in this version, but it's in the interim guidelines. If you have a seller who asks about it, you can just tell them that's what this is about. It is not about buyer costs. That will also be in the updated part of the form that this is not buyer inspection plans.
Yeah.
So anyway, sorry about that. I apologize. It was just, it went through about 45 people and nobody really brought it up, so nobody thought about it. But anyway, you guys, if you feel like that's been confusing, you're in good company. There's been plenty of questions on it. So, all right. We are going to, let's move to let's move to the buyer agency agreement. This will be relatively short just because we've already talked about a couple of the big things here. You may notice that the biggest change from January is that there used to be a blurb here all about how, all about amending buyer agency agreements, how the buyer didn't have to agree to more compensation, et cetera, et cetera, et cetera. That, removing that and putting this in there instead was in direct response to the brief in December that was filed that I talked to you guys about already. And then there was a Q&A on amending buyer agency agreements. There are times when amending a buyer agency agreement may be appropriate to get more compensation. But if you're just doing it to match whatever the seller's offered, when you've already made an agreement, then probably it's not going to work. There needs to be a benefit to your client, or provide additional services, or however, something that shows that you're not just trying to, win the lottery as a buyer agent. It's just not how the settlement, I've never read the settlement that way. But at the same time, there was a very interesting, I don't have the form up right now, but there's a couple interesting parts about this brief that was filed in December. Another part of their brief that was head scratching to me was their position on touring agreements and property showing agreements. And that's why if you use that form and you've seen the updated version from January, it has a line there of what you expect to be paid if you later sign an exclusive agency agreement. Because in the brief, they didn't like that process either. I guess they feel like if you tour a property with a buyer, you need to nail the buyer down to whatever amount of compensation you're getting forever and ever, amen, and it can never change, which I just think is utterly ridiculous. It's like, I don't even know what to say about it. Like, I'm gonna go on a first date with somebody and be like, all right,
Gonna get married.
we gotta get married. Let's make sure this date goes well, okay? To me, the attitude about it is they just don't practice. And I don't practice either. I would be horrible at selling real estate. I don't sell things, okay? So, to me, what you guys do is a very difficult job. And the fact that, I help you guys through it from just the legal side, is, difficult enough. That's about all I can really handle. But, at the same time, that's why like I said, to the maximum extent possible, the forms need to be able to accommodate, the settlement and make sure that people stay in compliance. That's what why that line was added. If you're wondering, that's why it's in there. So if you're using that form, contractually, it's not binding, it's not phrased that way, but it's to give the buyer an idea. I would say this, it continues to be the case, and I've been saying this from the beginning that the settlement was announced, value your services as a buyer agent, and make sure that's clear from the get-go. The Q&A also talks about builder bonuses, and things like that. If you incorporate them into your agreement, from the beginning, I think that's perfectly fine. Or if you got a buyer agency agreement right now, where you haven't made an offer yet, I think you could amend it and still be okay. I think that's still substantial compliance. So if you got something like that, for July, the buyer agency form, that's the section above here, will have a seller builder bonus checkbox line so that you can just fill it in. And you won't have to put on other specific amount of money. We already covered that. That's pretty much it for that one. Finally, the
A
last
quick
form,
question.
still getting plenty of questions on Form 220. I've already covered this a little bit today, but as just a final point, something we haven't covered yet. With respect to this form, the date in paragraph 3. Let's just talk a little bit about that. So Lori can attest that when we were redesigning this form, I don't think anybody thought that people were gonna turn around and use that as advertising material. I didn't. For me, this form has always been something where it is meant to give you the contractual basis for cooperative compensation, much like a referral fee, but also like a referral fee. There's nothing in the law that says that cooperative compensation has to be in writing, has to be on a form or whatever. I'm waiting for the either arbitration case or the lawsuit where somebody's not being careful about how they're phrasing things in a text message or an email exchange with another broker, and then they file a lawsuit on it. I've already had a couple hotline calls that are toying with it. And the reason that brings me back to the date in paragraph 3, the reason this date is in there is not so you can go to a listing appointment, have all this discussion with your seller, and then have him fill out the 220 and then put in a date that's the end of the listing agreement. That's not an effective use of the date. Can you do that? Sure. Like if you want to do that, that's fine. But in a market where a buyer, and especially if the market turns to more of a buyer's market, it is entirely possible that one buyer is going to have several agents. If that happens, you don't want multiple 220s just floating out there. This is also the reason why we inserted a date to end for the referral agreement. Okay, it's the same prospect here. Now, the reason that this date doesn't need to be super far into the future is because if the buyer and seller go under contract, then it's earned. And this will continue to be effective all the way through closing. It's going to function exactly the way it needs to. If I'm a listing agent, like that date there, mind you, it's totally negotiable between you and the buyer agent if you're the listing agent. But if I'm the listing agent, that's like 3 days from when a buyer agent contacts me. We either get under contract in 3 days, after we sign all this, or we don't. And if we don't, then I don't have to worry about you. That's the point. Now, if you're a buyer agent, it may well be that you want a little bit longer. Maybe you want 2 weeks, maybe you want a month, maybe you want 2 months, depending on your buyer. And you want that to be effective. That it's a negotiating point between you and the listing firm or the seller. Okay. But that's what that date is for and what it's meant to do. And then if the buyer and seller are going to contract, fees earned, you're good to go. Now, depending on your firm, there may be any number of ways that you use this date, the way you do things, and that's fine. If you've got an internal, way that's different than what I'm describing, that's okay. Just make sure you're doing it in a way where your seller's protected. And if you're on the buyer's side, that you've got your compensation protected too. So, but in any event, this should come first. Can it go at the same time? Sure. Separate documents. It can't be an addendum to the contract, but you can send them at the same time. That's fine. And the guidelines talk about that.
Hey, John.
Yeah.
Scott has let me know, and I apologize for really, we've got some questions on Zoom.
Okay.
So let me get around here and see, first of all, we've got the audio on Zoom. I've got that it is on.
That's
check
working, but I think we need to
microphone, we've got speakerphone on the owl is on. And so you'll need to turn the volume up.
While she's working on that, John, can I ask you a question?
Sure.
Can you, or have you dealt with any hotline buyer agents saying, calling a listing agent says, my seller is not offering any compensation. The buyer agent says, well, I have an interested party. We'd like to see it. They go show it, and then they call back and they said, my buyer will not make an offer without offer of compensation towards me.
Okay.
Have you gotten that call?
Yeah.
Okay. And I'm leaving it open-ended for a reason.
So-
Because I find that is
Well, they can offer harassment.
correct.
So there's actually, it's interesting you bring that up because I got this hotline call yesterday while I was in the car driving over here. And the interesting thing to me is that we probably need to revive the Q and A that we wrote last year on this. It's a very, very, very fine line between using your either your buyer's offer or your seller's acceptance, right, as a bludgeon to try and affect, agent
Right.
compensation. And the fact that, for all you know, the buyer and the buyer agent have had a very detailed discussion,
Right,
and this is how they're doing it.
right.
And it's not a bludgeon at all.
Right.
It's just a fact of the
Right.
financial situation. And so to me, the interesting thing about that is, it could also be handled with like seller concessions and other things like that. It doesn't have to be straight up cooperative compensation. So I don't know. What I would say to you is it really depends on the parties in the scenario, the kind of discussions they have with their clients, to whether that be a violation or not. And in some circumstances, it might be easy to figure out, in other circumstances, it may be impossible.
Best practice, so, okay, my seller might be willing to offer compensation, but we need to know terms.
Yeah,
Something to that effect,
Sure.
even if it's just a written, doesn't have to be written up on the offer, it just needs to be, give me something that I can go back with,
Yeah.
that's perfectly allowed, right?
yep,
Much like what you had already said earlier, submit the 220 ahead of the contract, spell out the termed contract in the email with the 220.
Right,
Right.
right, but right,
You should actually have those all the time.
Right.
Write the offer and send it with the 220
Right.
and sign the offer.
but don't just give me the 220 and tell me I'm not giving you my offer terms until you agree to compensation, that makes no difference to
Yeah,
me.
The offer.
That
to
makes no
me-
difference to me,
to me, that is, I agree with you, that to me is pretty far out of bounds.
Right.
Like, yes, you have to negotiate, you need to negotiate your agent compensation on the front end, that's what the code of ethics requires. Okay, yep, that's true. But to hold hostage any offer terms of your client when that's what the seller's asking for, the listing agent's asking for, that to me is like, okay, you're just like,
right,
I've got this buyer and whatever,
Right.
Just do it on 220.
Would it be,
Let me get this straight, because I get really confused. All right, so when we know we're working with a buyer, we know he's probably gonna be putting an offer in, so we're not really wasting the listing agent's time when we say, can I see this, copy of this, signed 220, right, before I submit the, before an offer is submitted. I mean, you have wrote it up, we know we're going to. It's okay to ask for that 220 agreement, signed.
you're assuming this, that the listing firm
Or
has
it's
seller
not.
signed 220 ahead of time. Technically, the 220 is the buyer document, not a seller document.
The problem with that is
It
if
could
you have
be,
a
but,
buyer needs to know if they're looking at properties, whether they're gonna have to pay the commission or not before they look at it, because that
Right,
affects.
so we can call and see if there is.
I'm actually,
That's what I'm.
I had buyers say, I don't wanna look at properties, I might have to pay the commission. on it."
Yeah, and so I'm always going out there, and I need to know now, and I start showing property before. And of course, he's a qualified buyer who's ready to go, I'm not saying that he's gonna make an offer, but I always call the agent and say, is he offering compensation, is he signing 220, will he sign 220, and they tell me, basically. So that, yeah.
You should do that.
Yeah, but I've had sellers say, I don't want to commit to a specific number until I get an offer.
yeah,
Yeah,
So
that's
so we don't
natural.
have, right, we don't have a 220 pre-signed with a number already locked down.
If that's the case, you should submit it to one.
Yes.
All right, Scout has been following downstairs. I attended the state of the county meeting this morning and, Bob Woodard can talk, as you know, and he readily admitted that at the meeting, so it went a little longer than we thought. But Scout's been following along here and, I know we've got about 20 people on Zoom, and so there's some questions in the chat.
Winston, do you wanna try asking your question again? I think we've got the volume figured
You
out.
need to, unmute, there you go.
Can you guys hear me?
No.
Well,
Can you hear me okay?
Okay, hold on.
Yes? Yes, you can hear me?
Well, they're figuring that out, just
Here, yeah, there you go.
Is the work with real estate agents
I'm here.
disclosure gonna be updated in July?
Let me see if this. Hello.
yeah, the working with real estate agent. Form, that's a, form from the real estate commission, so. I don't,
Cause it says on here, it says your agent must enter into a written buyer agent agreement with you before making it a written offer or an oral offer. It doesn't say anything about proportional.
Well, they don't care about it. There's a lawsuit. Yeah. Care less.
Hey,
But what we're.
can I ask a question?
Yeah. Lawsuit thing.
Right.
Can you hear me
Okay.
okay?
Yes, we can hear you now. Hold up just a second.
Okay.
All right, go ahead.
Go ahead, Winston.
Okay, it's actually back on the buyer side. I really like the way the dual agency thing is laid out now. That's really clean. You said something that was that kind of stuck with me. You know, buyers bonuses for new construction or anything like that. And I guess you said that could be added into like other specific amount and kind of set that up like I'm just throwing this out there like buyer's agency of blah 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 and then a builder bonus or whatever it is for X amount of dollars. And can you give me an example of like how you have seen that or which is how we could, go about doing this? Because I don't like filling these blanks without knowing somebody's had some success with this.
The way, so there's a Q&A that came out on this, I want to say last week, Monday. And the suggested language, and you can phrase this however you want, but something to the effect of, on the other specific amount line, seller or builder paid bonus of X amount if offered and paid by seller and builder, something like that. Just something to make it clear that, the buyer's not actually paying it, right? It's just, if it's offered and paid by the seller or builder, then it's something potentially out there. As long as you make it a specific amount, so like either a percentage or like a specific dollar amount. Let's say that you put some language like that in there, and then the seller builder bonus is actually less. Well, that's fine. You can just waive it or whatever. I also think there's situations where you could, if you come across an unexpected seller builder bonus, you don't have it in your buyer agency agreement, but your buyer gets a benefit, by getting it. Let's say that they get, additional, functions in a new build, maybe some extra things, or you share part of it with them and they want to do that. Those sorts of scenarios, I think, would be appropriate to amend a buyer agency agreement to include that, even if you don't have it in there from the get-go. But as far as putting it in from the beginning, then some language in there just saying if it's paid, offered and paid by the seller or builder, then, a specific amount.
Okay.
Is there anybody else on Zoom? Do we have anybody else in the chat?
Don't think so.
Question? Okay.
Anyone want to speak up?
A question on the dual agency compensation part. So from the listing agreement side, we can write that specific amount in. It's a lot easier if it's dual agency with the same agent to do that. If it's dual agency with two different agents within the same firm, do you have a recommendation for the best way to kind of codify that? And we're not putting it into the section below because that's saying authorized and offer. Is there a good, 220 is cooperative compensation, so with the same firm, not necessarily.
Yeah, so what I would do is on something like that, there's two different ways. Number one, I think it's really important to emphasize that if you're representing a seller, they have no duty to offer cooperative compensation to any cooperating agent, including agents within your firm. They just don't. Like they have, you have a fiduciary duty to them, and I would contend that that fiduciary duty includes aggressively negotiating cooperative compensation to their benefit. Okay, that means that when it comes to dual agent situations, then there's a couple different ways you could go about it. So we already covered the unrepresented buyer, the single agent, dual agency. That would be under firm's fee and B. But if there's a special way that your firm wants to do two agent, like firm dual agency, two different agents within the same firm doing dual agency, then you can either do the checkbox, and doing it in text policy, you can put it in paragraph 19, you can spell it out there. Or, if you're gonna take the fundamental premise that I'm talking about, that a seller just doesn't have a duty to offer it to anyone, including a buyer agent in your own firm, then you could just negotiate it the same way that you would with any other buyer agent. So your firm can do it any of those three ways. Like, there's no right or wrong way to do it. And some firms have very strong feelings in this arena, and that's fine. Like, you can be, like Drake and put all your strong feelings in the agency agreement, however you want, okay? So yeah,
So if we were going with kind of the option 3 there, where like they're free to bring it with an offer or what have you, which I think makes probably no sense personally. A 220 be appropriate to use, or should we have a different form altogether since it's technically dual agency compensation? Or can we consider dual agency compensation to the buyer side, cooperative compensation respect?
either way,
So we could just have them,
however you wanna do it, yeah.
so we could have another agent from our firm say, okay, seller's gonna pay X%, and we write up the 220, and we just have our firm on both sides sign it.
Yeah, I feel like we get it drilled into us that if it's all within your firm, it's not cooperating.
Mhm.
Cooperative is only if there's another firm, but it sounds like the law doesn't care about the difference there.
Yeah, under the old MLS rules, the old MLS rules didn't care, yeah. If you're a cooperating broker, you just simply were not the listing broker. If you go back and look at the old rules, it talks about listing broker and cooperating broker. It does not talk about listing firm, cooperating firm at all.
So if you're dealing with the same agent who is the dual agent, so instead of doing this addendum, which they suggested in the little article that came out on Monday, can you put that in a fee or in paragraph 19, or does it need to be separate?
It doesn't have to be separate. It could be,
Be there?
it could
Is
be
that what I need?
other fee, paragraph 19. Like I said, I'm gonna expand this other fees line so you guys have more flexibility just put it there instead of doing it addendum. This is one of those things where I did not anticipate where you guys were going, so I apologize, but we can get some additional lines in there. Help you guys out. Other questions?
Anything from Zoom world?
I have a question. Maybe it's for Willow though. So when the new forms come out, thank you, we like to start using them right away. And it took an unusually long time in January, was it a month, I think, for it to get to zip forms. So who's that?
Interesting.
Is that the real estate commission? Is that North Carolina? Is it OBAR? What the heck?
It's,
Don't ask us to start using them and then give us a month before
yeah,
they arrive.
yeah. And the other thing too is they had like a 30-day grace period.
I wouldn't mind the grace period, nobody ever uses it, we encourage them to use it all the time, but we
Yeah.
can't use it, they're not in there.
Well, usually the grace period is 60 days.
Right.
Yeah,
And so it's a 30-day grace period on this. What I would say is dealing with it on my end, it was mostly zip forms. I don't know what was going on, but here, no, it was zip forms, but not in a bad way. So all the fields, right? Well, with new forms, they have to
Yeah.
redo all the fields. And so that was my understanding of why it was taking so long on their end. Because they were having bug issues trying to make the fields populate the correct way. And
my suggestion would be, before you tell us, you tell zip form. And then you say, hey, here are the new forms, and zip forms, we'll have them in there tomorrow morning.
yeah,
You can always bust out your typewriter and.
I mean,
So I can offer some perspective if anyone cares on that. We revised our attorney worksheet, a very simple one-page form, and I had to go back and forth with zip form. For actually what they do is they recreate the entire thing in their
they
own
do, and they tell you
system.
per
It's
page.
not like they could just import a
Yeah, I
PDF.
understand, we have custom forms in there.
So I feel like I wasn't working with the best and brightest. I Cause I was like, no, that's not what the form that I gave you says, and then they would go, like this, and I go, no. So imagine doing that with a very important actual legal document.
Yeah.
No, I will-
To me, just about to go.
Well, normally,
Very quick.
normally in January and July, they know the new forms are coming. This was one that came on an odd cycle, so I would imagine what zip form does, is they anticipate the new forms coming out, have people engaged to do it. This one just popped up unexpected.
No, we've been keeping them busy. Yeah, usually it's a couple months of, we do the final proofing, we get it to them, they usually have a month before it gets into zip forms. So, yeah, it was a very tight turnaround for everybody involved.
I'm just going back to my idea, and if nobody else thinks it's a good idea, that's fine. Instead of saying illegal, in reference to, like, can't we just say not per regulations or not per, can't we soften that so it doesn't jump up at the public and the dual agency can become illegal?
I mean, I can bring that up with the forms committee, but I've never had anyone else, have an issue with that language, but I can bring it up.
Not forbidden.
Tammy Aycock had a comment, they have changed their policy now that you have to send them PDF files.
What does that mean?
Zip
Zip
form.
So hopefully that's, I guess that's
Yeah, I
it.
mean,
That's what I sent them.
Right, that's what you said, last time. You didn't send them the PDF, but.
I mean, your story doesn't surprise me, but I agree with you, we should just be able to give them PDF and they can.
Right.
If their software is worth anything, it's not hard to,
You can presumably built on something made in 1992.
yes. That's my.
That's how the world works.
Form has the old form still, we can't use them, we have to try and get a hold of the new.
No, if a form is in zip forms, like let's say an old form is still in zip forms, that's because it's still in the grace period. During the grace period, you can use either one. Yeah.
I will say, like, we've moved over to mainly using DocuSign for our stuff, so like, even filling out the forms in DocuSign, it's not quite as good as zip forms, I still like zip forms a bit better, but DocuSign has been very fast in updating their doc. So we had those documents from DocuSign very quickly.
All right. Well, listen, if we didn't get to your questions, it's fine. You can call the NC Realtors legal hotline. If you need the phone number for that, you just let me know. Or you can email legalhotline@ncrealtors.org. Either one of those, we can answer your question. So anyway, thank you guys.
I appreciate you being here.
Thank you.
Yeah, thank you.
Hey, actually.
What copies of that in the office, ones for instance,
Of course, it's not hard. State files.
yeah.